the court. I'm struck by the way the state starts out in its brief discussing the sovereignty of the people and the ability of citizens to determine how governmental power is exercised, and the importance for the people of Albuquerque to be able to hold public agents accountable. Now, undoubtedly these are important considerations, but the reason that I'm struck is because this line of reasoning seems to suggest that a different standard should apply to police officers accused of a crime. And when they're accused of a crime, they shouldn't be entitled to the same protections with respect to venue that someone else accused of a crime would enjoy, simply because of the countervailing public interest in upholding their sovereignty. Now, Officer Perez and Officer Sandy are not claiming to be entitled to more protections than allowed any other citizen accused of a crime. But they're certainly not entitled to fewer protections. They're not seeking an unfair advantage, only a fair trial. And a truly fair trial should be in everyone's interest, including the state's. Now, the House case tells us that in order to be entitled to a change of venue, a movement must simply demonstrate no more than a reasonable probability that a fair and impartial trial is unlikely in a particular venue. Only a reasonable apprehension that a defendant will not secure a fair and impartial trial is necessary. In fact, and this is very important, House found that the trial court properly ordered a change of venue when it concluded that a fair trial could not be guaranteed in the first venue. Now, as we've talked about in the brief, and as you well know, we don't need proof of actual prejudice, only presumed prejudice. And while it's certainly within the court's discretion to conduct voir dire prior to making a determination about whether excess prejudice has infected this case is particularly unsuitable for that method. As the state noted concern about a jury veneer panel of 1,000 to 2,000 prospective jurors if the trial were to be held in Albuquerque. And the state suggested that it would be difficult to have a panel of that size in Las Cruces given its smaller population. It would be difficult, but it would also be unnecessary because the knowledge and the prejudice about the case would be so much less if it were held there. But to go through the entire voir dire process here with such a large panel only to ultimately conclude that it should be moved would be the height of inefficiency. It's much better to move the trial first. House tells us that prejudice may be presumed if the community is so saturated by coverage that a trial would inevitably take place in an atmosphere of intense public passion, because under such circumstances there's a reasonable probability that prospective jurors were exposed to the sensational publicity as well as the emotional atmosphere in the community, and that many of them are already predisposed for or against one of the parties in this case. You only need to look at the cameras covering this preliminary hearing on the motion to change venue today to see that the public interest in this case is just as alive as it was right after the incident, as it was at the preliminary hearing. It continues with no diminution today. We talked a minute ago about how a police officer or another public official should receive the same protections with respect to a fair trial as any other citizen, and should not be subject to a trial in a hostile venue simply because it's important for the community to be able to judge them. But the fact that these are public officials makes other types of prejudicial information all the more likely to creep in and be held against them. There's been a lot of talk so far about coverage of this particular incident and its potential effect on a fair trial. But the issue is not simply publicity about these individual defendants and this particular incident. The state has shown through its course in the preliminary hearing and in filings throughout this case that its strategy is essentially to put APD and its command structure on trial. The preliminary hearing was replete with evidence of how many officers were on the scene, how much firepower all those officers had, allegations of numerous mistakes by others at the scene, second guessing about how many missed opportunities others had to avoid this situation, and allegations of a culture within APD that led to the shooting, rather than testimony by a single witness that what these individual officers did under the circumstances they were faced with was unreasonable. The focus was much broader than these two individuals. Now, the fact is, evidence of the extensive Department of Justice findings about the culture at APD would likely not be admitted at trial. The fact that the shooting led to sustained and violent protests throughout the city, the likes of which the city hasn't seen since the 70s, would likely not be admitted at trial. The fact that the city settled with Mr. Boyd's family for $5 million as a result of the shooting would likely not be admitted at trial. But all of that prejudicial information has been reported on extensively, and it's common knowledge in this community. And the state is counting on people knowing about that. One cannot look at the pretrial publicity about this case, in particular when added to the other atmospherics about other people not on trial here, especially when combined with the state's likely trial strategy, and feel comfortable that a fair and impartial trial can be guaranteed in this venue. Now, the state suggests that publicity in this media market shouldn't matter because anyone can go on the internet and learn information about the case. But of course, the difference is that those outside of this media market have to affirmatively go to search for that information, as opposed to having it relentlessly presented to them, as Mr. Bregman referred to, in their local paper and news broadcasts. And one of the things he didn't mention as far as the news coverage goes was not only the facts that were presented and the arguments that were made and the evidence that was there, but the analysis. Each newscast had an analyst telling people how they were viewing the information, who seemed credible, who didn't seem credible. That's all out there as well. Now, the state, in their brief, brings up the Boston Marathon bombing case, the Tsarnaev trial, as an example of a high-profile trial that was not moved despite massive publicity. Well, they did keep it in Boston, and they got their conviction, and they got a death sentence. And the decision not to move the trial is already the subject of an appeal that I'm sure is going to keep the courts busy for years. So the court may have made that decision, but that's certainly not the last word on whether it was the proper decision to make under the circumstances. But as discussed in our brief, the standard applied in the Tsarnaev case is simply not the standard applied under New Mexico law. Federal courts limit a change of venue only to the most extreme circumstances. We do it differently here. We apply a reasonable probability standard instead. So I submit to you that under New Mexico's standard, it's highly unlikely that the Boston Marathon case would not have been moved. They were just operating under a different standard. In addition, the Boston Marathon bombing was subject to significantly more national coverage than this case ever saw, making a change of venue less likely to be effective in that case. And finally, I'm concerned about the state's statement in its brief that without a scientifically valid survey of prospective jurors in the community to see whether the entire jury pool has been so tainted as to make it impossible to select a fair and impartial jury, the defense has not met its burden. First, I'm concerned because, as discussed in the briefs and as we've discussed this morning, that grossly misstates the defendant's burden. We don't need to show that the entire pool is so tainted that it's impossible to select a fair jury, only that there's a reasonable probability that a fair trial is unlikely, or that it can't be guaranteed under the circumstances. But I'm also concerned because, as Mr. Brigman mentioned, no case has required such a survey in order for the defendant to receive a change of venue. To have such a requirement as the state seeks to impose in this case, would set up that two-tiered system of justice that we just talked about, where the ability to enforce one's constitutional right to a fair trial and an impartial jury is dependent on having those substantial resources necessary to engage a pollster. And not just a pollster to take a poll of potential jurors here in Bernalillo County, but to have to sample other parts of the state to show that those areas were less prejudiced than here. $40,000 was the estimate given. That is resources that these men do not have and shouldn't be required to have in order to secure this most basic right. Thank you, Aaron.
Judge, I agree with Mr. Roman. These police officers should have the same protections as every other defendant. They should not be beneath the law, but neither should they be above the law. And the guiding principle for this court in this case is that these defendants should be treated just the same as any other defendants accused of second-degree murder. And in thinking about that, I thought about what are the most comparable cases as far as the amount of publicity and the constant drumbeat of publicity as this case. And the comparable case is the reverse situation, where a citizen is accused of killing a police officer. And there have been 6 men prosecuted for shooting a local police officer in the last 35 years, 5 APD officers, and 1 person was prosecuted for shooting a Bernalillo County sheriff's deputy. All of them were tried in Albuquerque despite the massive publicity. All 6 of them. Unlike in this case, where there have been articles both pro and con, some supporting the police officers, some against the police officers, all the publicity in those cases about those men who shot police officers was negative publicity. It was not neutral, it was negative. And despite the defense claims in each of those cases that a fair jury could not be found, the results of those ultimate trials are instructive, I think, for the court. Only 2 of those 6 were the accused men convicted the first time around. Michael Astorga was convicted here in Albuquerque for the 2006 shooting of Bernalillo County Sheriff's Officer James McGrain. Joel Compton is a person I prosecuted as a young prosecutor for the 1983 shooting of APD Officer Gerald Klein. He was convicted back in the 80s, first time around, and was given the death penalty. 2 of those juries that were picked here in Albuquerque with all the massive publicity about a police officer being shot resulted in hung juries. Vincent Paul Candelaria, there were 2 hung juries in the 1986 shooting of Sean McQuessy. He was never convicted. In fact, he finally pled to some armed robbery charges, and that ended the case. Merle Chamberlain, who is the fellow who shot John Arthur Carrillo in 1987, the first trial was a hung jury on murder on the murder charges, and he had to be tried a second time, and then he was convicted in the second trial. One of the cases that was prosecuted here in Albuquerque resulted in a conviction, and then a reversal on the Supreme Court level, and then came back here and was tried in Albuquerque again. And Van Bering Robinson was acquitted in the 1980 shooting of Phil Chacon. That's an APD officer. And then, of course, one defendant was found incompetent to stand trial because of mental illness here in Albuquerque. That's John Hyde for the 2005 shooting of APD officers Michael King and Richard Smith. And so what I say to the court is, if there has never been a case where a change of venue has been granted in the massive publicity that surrounds a citizen shooting a police officer, this case should be treated the same, and these men can get a fair trial, just like all the court ruled, district judges here ruled that all of these people who were accused of shooting a police officer could get a fair trial, and it sort of works out that way, 2-2-2. The key, I think, in all of these is a thorough jury selection with pre-selection questionnaires. I will tell you, as a defense lawyer, I, like these defense lawyers, didn't think that was possible. My husband and I tried the Terry Gilbert homicide case here in Albuquerque, filed a motion for change of venue. This is the woman who shot someone who was breaking into her house in the dark, and it turned out to be her estranged husband, who was the county commissioner, Gene Gilbert. The problem that was widely reported and resulted in massive amounts of coverage, probably more even than this case, both locally and nationally, was that 20 years earlier she'd had to shoot another husband in self-defense when he was beating her with a homemade blackjack. And that sort of then generated this Black Widow theory all in the press, and this was even pre-internet. I think there was more publicity locally and nationally than in this case. We filed a motion for change of venue in front of Frank Allen. Frank Allen said, we can pick a jury. And allowed us an extensive questionnaire. We sent out 150 jury questionnaires. 90 of those questionnaires came back and said she was absolutely guilty. They already made up their minds. She was guilty. She was a Black Widow killer. 30 said they had never heard of the case. And of course, those aren't the jurors you want from either side, because they had to be living under a rock to have not heard of the case, and somebody would ultimately tell them about the case if they got on the case. And 30 of them said they'd heard of the case, but still maintained an open mind. One person wrote on his questionnaire, either she is a double murderer or she has really bad taste in men. And somebody who could conceive of two alternate theories, that was precisely the kind of juror that we wanted on that case. And the jury of 14 was selected from those 30 who said, I've heard of it, but I still have an open mind. And in fact, after that jury selection, Terry Gilbert was acquitted on self-defense grounds by a careful jury selection combined with a questionnaire. Let's talk about the law. All of this, the touchstone of all of this is the New Mexico and the United States Constitution. The New Mexico Constitution says that the defendants are entitled to an impartial jury of the county or district in which the offense is alleged to have been committed. And there is a reason why we try cases in the place where it was committed. It is, I think we've talked about that in our brief, the community has an interest in seeing justice done, and has even a higher interest in this case where it is Albuquerque police officers who answer to the people that this community should decide what's acceptable behavior and what is not. The venue statute says it should be changed from a county free from exception when the attorney files an affidavit he or she believes they can't obtain a fair trial because, and there's two things I think that apply here. One is that the inhabitants of the county are prejudiced against the party. It is this second aspect of the venue statute that I think if they have that burden, they had to do some polling to prove that second prong. And there is no evidence before the court that the inhabitants of the county are prejudiced against the party. There just isn't anything in the record. I wasn't the one who said they were going to do a survey. If you'll recall, Judge, the last time we were in front of you, they said when you asked us when could we try the case, we said we could try it in the next month. And the defense asked for a year and said one of the things we have to do is do a survey and polling about the prejudice in the case for our motion for change of venue. So I was surprised when that had not happened and that was not submitted. And in light of that evidence, no evidence being presented about that, I think two cannot form the basis for the change of venue. I think they're going with the third, which says the third thing in the venue statute, number 3, that says public excitement or local prejudice in the county in regard to the case or questions involved in the case are such that an impartial jury cannot be obtained in the county to try the case. And that says, can we get the test for that is, can we get an impartial jury with a questionnaire and with jury selection or not? That's really the question in this case. They haven't done anything, and there's nothing in the record except for Mr. Bregman's testimony about talking to one person and getting a quote for $40,000 for surveys. You can get them much cheaper than that in Albuquerque. I would ask the court not to consider that unless there's some evidence there. It is exactly what they did in the Boston Marathon case. There were all kinds of surveys done, not only of Boston, but of other jurisdictions to see where they could move it, including Washington, D.C., which is where they were requesting it be moved. And polls are fairly simple to see how the publicity has affected the potential jury pool. It's not enough that there's been a bunch of publicity, and not just how has it affected the jury pool here, but how has it affected the jurors in Las Cruces. I think the Tsarnaev case is instructive for this court on how to apply this standard that they talk about in House, a pre-internet case, on what is presumptive prejudice. And the Tsarnaev case, since all this, the touchstone of all this is the U.S. Constitution, the Tsarnaev case has a great quote from the U.S. Supreme Court over 100 years ago when they first were interpreting these rights as related to change of venue. The U.S. Supreme Court said, this is 100 years ago, before the internet, before the kind of newspaper and television coverage that we have. In these days of newspaper enterprise and universal education, every case of public interest is almost as a matter of necessity brought to the attention of all the intelligent people in the vicinity, and scarcely anyone can be found among those best fitted for jurors who has not read or heard of it and who has not some impression or some opinion in respects to its merits. And what the U.S. Supreme Court said then in the Reynolds case was that any high-profile case will receive significant media attention. It's no surprise that people in general, and especially the well-informed, will be aware of it. And the test, knowledge, however, does not equate to disqualifying prejudice. Distinguishing between the two is at the heart of the jury selection process. And that's why the court said, we're going to go ahead with the jury selection process and see if a fair jury can be selected. The Tsarnaev case cites both the 1993 bombing of the World Trade Center, where 6 people were killed and over 1,000 were injured, and that was tried. The 6 co-conspirators were tried in the Southern District of New York, right where it happened. The 2001 World Trade Center terrorist attacks, they tried Zacharias Moussaoui in Virginia, just minutes away from where his actions had led to the plane flying into the Pentagon. The most important, I think, thing in Tsarnaev is they found that despite the fact that some people had made up their minds based on the extraordinary, again, all negative coverage, there was no positive support for Tsarnaev in any of the reporting, they were able to find jurors in Boston that could be fair. And they talked about doing the jury questionnaire and the additional challenges that they gave to people, and then cited the Supreme Court's decision in Skilling. That was the case of the Enron executive. Remember, Enron failed right there in Houston, and the trial was held in Houston. And they actually have a definition that's very similar to the House definition of presumptive prejudice and what factors you need to look at. The first, both for House and in the Skilling case, was the size and characteristics of the community where the crimes occurred. There is no doubt that Albuquerque is the largest city from which we can draw jurors in the entire state, and the larger the city, as they said in the Tsarnaev case, the more your odds are of getting a fair jury. Secondly, you look at the impact on the community. In the House case, they define that as juror prejudice, statements by politicians, and fixed opinions. And again, if the defense is relying on fixed opinions, they have nothing before the court that talks about the fixed opinions of the public. There is no polling, there is nothing that says anybody's opinions are fixed or that we can't find people who can be fair in this case. In both Skilling and House, they talk about the neutrality of the publicity, and in this regard, Judge, the interesting thing about this case is the publicity in this case has not been all negative about these defendants. In fact, in the documents that you have, that we just got this morning, there has been a lot of publicity that actually is pro-police and anti our victim, James Boyd. In fact, immediately following the shooting on March 21st of 2014, there was a report on television. The police, as they've done in many of these shootings, look up all the bad things about the victim and then talk about those in the press, and all of those were put in the press, including an inaccurate report of what actually happened out there at the scene to sort of defend the police conduct. And that happened over and over again through Chief Eden and other politicians. Then there was the reporting after the preliminary hearing about how the officers had been fired and how they were setting up a website to get money for them, and that support was rolling in for the charged Albuquerque officers. I would say probably 25 to 35% of the articles that they've included are pro-police officers in this case. They've included in your stack of articles about this case things like that the K-9 Rex might be put to sleep because Officer Sandy was retiring. Those things aren't negatively impacting this case at all, and there are a number of articles like that that really have nothing to do with whether they affect the jury pool. It is with some irony that Mr. Bregman led off this discussion of this horrible adverse publicity, because the picture that is repeated most often in the press, the person who is most pictured in all of this press, both on television and in the newspaper, after the two officers themselves, is Mr. Bregman, who has been making statements, public statements ever since the trial happened, making public statements about the DA, making public statements after, both when she decided to bind them over and then after the preliminary hearing, criticizing the judge. And so it is with some irony that he is the one saying there's been all this negative publicity. I will say to the court, as far as the live streaming was concerned, Judge Candelaria asked for both sides permission whether they objected to the live streaming, and the defense did not object to the live streaming. And so in that regard, I think they have waived the problems that they now are claiming that created. What is the solution? It is a thorough jury selection. I think we summon an expanded jury pool. I don't think we need 1,000 to 2,000. I think that number originally came from the defense. I think we can send out questionnaires 6 weeks or so before the trial, and probably need to send out maybe 400 to 500 of those to potential jurors. What happened in Tsarnaev is they allowed a lengthy questionnaire that both sides worked together to develop with the court's input. They sent them out. They gave both parties ample time to review the questionnaires. Some people, as in our Terry Gilbert case, just weren't called in. The 90 people who said on their questionnaire, "I can't be fair, I think she's guilty," just weren't even brought in. And then you bring in, and you need to give both sides time, in addition to review the questionnaires, to research the jurors and consult with jury advisors if they want them, and then permit the parties and the court to question the jurors. In Tsarnaev, they brought smaller groups of 20 or 25 to the courthouse at any one time. They did individual voir dire there. I don't think we need that here. I think we can question probably panels of 20 to 25 pretty efficiently about their biases and prejudices of those who make the cut after the questionnaire. The court in Tsarnaev found that thorough jury selection was very effective at exposing the bias, ignorance, and prevarication, I think was the term they used of the jurors, and in seating a fair jury, even in that case that had so much more publicity than our case. The problem for us, Judge, is, I guess, the internet, which Mr. Bregman says we can't tell how many times this has been viewed. Well, you can. You get on YouTube and you look at the number of people who viewed them. There are a number of sites that have played this video over and over and over again. It's millions of people have viewed this. Millions of people, not just in New Mexico, but around the world. I have run into people from Europe, and a woman from Sweden who said, "You're from Albuquerque." I didn't say anything about being a special prosecutor. She said, "Isn't that where they shot that homeless camper?" I mean, it's been seen all over the world. And that's the problem that the courts have to deal with now with the internet. It's been seen in Las Cruces. It's been seen everywhere in New Mexico, and it's been seen over and over and over again because people replay it every time they do a story about this. The whole preliminary hearing has been posted by somebody on YouTube. I don't know who did that, but somebody posted the entire preliminary hearing on YouTube. So moving it doesn't get away from people being able to see the preliminary hearing. Having said all that, we think it shouldn't be moved. And we've talked about the public policy reasons for that in our brief, I think, Judge. But if it is moved, the statute says where it should be moved. And what does the law say? The venue statute 3837 says it shall be removed to some county of the nearest judicial district that is free from exemption. And that judicial district is Santa Fe, not Las Cruces. It has, I think, fewer than 40 articles in Santa Fe, much less coverage in Santa Fe than there was here in Albuquerque. And in this place, Judge, I want to call out the real reason for seeking removal to Las Cruces. And that is because it's perceived as a more conservative jurisdiction than is Albuquerque or Santa Fe.
He's given testimony in notorious national police shooting cases, including the San Francisco Bay Area Rapid Transit case, where a Bay Area Rapid Transit officer was tried for homicide after he sat on a man who was lying on his belly, had a handcuff on, and the unarmed man started to move, and so the officer drew his gun, put it into the small of the person's back, shot and killed him. Bill Lewinsky took the stand and explained to the jury why that was reasonable under the circumstances. He purports to conduct studies through his Force Science Institute Research Center that talk about how police officers think, how their brains work under stressful circumstances. He focuses only on police officers. He gives training to police officers that is based upon the studies he conducts. But much of his research, if not all of his research, bears the telltale signs, the telltale warning signs of junk science. Much of it is not peer-reviewed, though that is peer-reviewed is not peer-reviewed in psychology journals, but in police magazines. His studies are never fully published with all the data included. Instead, they're summaries of his studies. No one in the industries try to repeat any of his studies. He's come up with theories that suggest that a bad guy with a gun can draw the gun, point at an officer, and then turn around and start to run in less than 1/2 of a second, but that it takes an officer 1.5 to 2 seconds to react to that, draw a pistol, and fire. And he's also suggested in some of his studies that once an officer makes the decision to fire and starts the process, it is physically impossible for them to stop. And so he combines these 3 studies that he's done that no one ever tries to repeat to explain why so many police officers shoot people in the back. So when he was named as an expert witness in this case, we interviewed him and we asked him about his studies. And he acknowledged that there are no other psychologists in the country doing the kinds of research that he does. He acknowledged that he does it primarily for the law enforcement community. He acknowledged that nearly all of his work is published in law enforcement journals, not scientific journals. And he admitted that essentially no one has attempted to repeat any of his studies. So we asked about his involvement in various cases, his multiple testimonies in secret grand jury proceedings for officer-involved shootings that resulted in no bills. Then we started to ask him questions about things that would relate to his bias. And of course, one of the most important things in bias is money. So we asked him about money and how much money he makes based on his relationship with police departments. Eventually, he gave a figure of between $1 and $2 million a year as the revenue generated by training police officers for the Force Science Institute. Now, it's an S-Corp. It's not a non-profit, not attached to any public university or anything to that effect. It's an S-Corp, and he and one other person are the sole shareholders of that S-Corp. He said between $1 and $2 million a year was the training revenue. But he also admitted to training between 6,000 and 8,000 officers per year. Now, assuming that a day's training for those officers funded by ostensibly taxpayer money at $1,000 a day, we know the math right there is not correct. That would be $6 to $8 million. But he actually told us that an average day's training for these officers was between $7,000 and $8,000 per officer per day. So if we do the math there, we're actually looking at revenues for training officers between $42 and $64 million per year for Mr. Lewinsky. Ultimately, the state filed the Alberico motion to limit his testimony. He had attempted to testify in 4 areas. At the preliminary hearing, the judge limited his testimony to only 1. The subpoena we served him with on the stand was really intended to address 2 things. One, to explore the extent of his bias, because there was that question about the money. It was also to get the source data for his opinions, because when we asked him, what studies are you relying on, he wouldn't tell us specifically which ones. He just gave a general overview of which ones they were. And he said we could just find them on his website. When we interviewed him at the pretrial interview, he said he wasn't really sure exactly what he was going to say at the preliminary hearing. He hadn't formulated his opinions, but he gave us a general idea. So we needed the studies he was actually relying on. If we're going to potentially try and find somebody in the same or similar field to refute his testimony, we need to get the hard data behind his studies. And that's the second reason why we served him that subpoena. But beyond that, it's also very easy for him or any party to slip in a different human being who would rely on the exact same studies, the exact same conclusions from those studies, to give the exact same opinions without exposing his bias to the jury. So that's why we needed that information. Never produced anything. Instead, counsel for Defendant Pettis simply sent a letter objecting to it. So here we are, and here's the state of those things. We've subpoenaed the documents, we never received them. The sole basis for the defendant's objection to the subpoena appears to be, or at the time was, that we don't know whether he's going to be a witness in this case, so your information related to him is irrelevant. They did not object to the form of service of the subpoena, the form of the subpoena itself. They provided no substantive objections as to the nature of the documents or information we were seeking, they simply said that we don't know if he's going to be testifying at trial, therefore you don't need to worry about him right now. But the truth is, we do need to worry about him for two reasons. One, there's no substantive issue why they can't indicate one way or the other whether they intend to call him. Nothing, as far as I'm aware, has changed in this case since the preliminary hearing. The evidence is still the same. As I pointed out in the motion, the rule of criminal procedure required the defendants to submit to the state and to the court their witness list, who they intended to call, or reasonably expected that they would call at the time that they reasonably expected to do so. I'm not aware of any reason why they can't give an answer as to whether they intend to call Bill Lewinsky in this case. We're asking for this now because pretrial motions in this case are due June 6th. Obviously, I've given the court a taste of the tremendously controversial nature of the information and the person who bear that information that a Daubert motion in this case would entail. And obviously it would take quite a while for that to be prepared, for the litigation in that to be fully completed, and for the court to hear it and consider it and issue an opinion. So we need to start moving on this. But we also want to make sure that Bill Lewinsky can't send someone to stand in his stead to shield his opinions from the bias they obviously potentially have, and that the jury should be fairly informed of. And so we need to know who, if anyone, affiliated with or relying on the work of the Force Science Institute is going to come and talk to this jury so we can be prepared to meet it. Beyond that, though, we want to avoid delays in this case. The state, as the court will recall, told the court we were ready for trial as soon as possible in this case. The defense asked for much more time. What we don't want to have happen is for the defense to say, we don't know whether we're going to call Bill Lewinsky. Let's wait a while. They ultimately decide they are going to call Bill Lewinsky or somebody affiliated with the Institute or who relies on his information, and then there'll be subsequent litigation about whether we're entitled to this material, because that will delay this case, because that will be one step in the chain of steps necessary for the pretrial motion on Daubert and Alberico that will delay all of this. And so we're asking today for the court to compel Bill Lewinsky to provide this information. And if he is not willing to do so, then he should not be allowed to testify as a witness in this case, nor should anyone who relies on his work or is affiliated with his work be allowed to do so.
Nick Audio on behalf of Defendant Perez. Your Honor, Defendant Perez retained Dr. Bill Lewinsky to provide an expert opinion at the preliminary hearing in this matter. After Defendant Perez retained Dr. Lewinsky, he disclosed Dr. Lewinsky as an expert opinion who was going to testify at the preliminary hearing. As the prosecution noted, after Dr. Lewinsky was disclosed, the state conducted an in-depth interview of Dr. Lewinsky on July 17th of last year. Following that interview on August 6, 2015, Dr. Lewinsky provided expert opinion testimony at the preliminary hearing in this case. During Dr. Lewinsky's testimony, the state served Dr. Lewinsky with a subpoena that commanded him to produce approximately 12 different categories of documents. In particular, that subpoena asked for income tax returns for Dr. Lewinsky's business, his personal tax returns, profit and loss statements for his business, documents related to his work on this case, and information related to several studies that he has completed throughout his career. Following the preliminary hearing on August 27th, after Defendant Perez received an extension from the state, Dr. Lewinsky provided the state with written objections pursuant to Rule 5-511. Accordingly, because Dr. Lewinsky objected to the state subpoena, the state is not entitled to inspect those documents or to receive any copies of those documents unless this court orders him to do so. Now, there are two major reasons why Dr. Lewinsky should not be ordered to comply with the state subpoena. First, Dr. Lewinsky should not be ordered to comply because the information subpoenaed simply is no longer relevant in this case. Defendant Perez has not retained Dr. Lewinsky to provide an expert opinion at trial in this case. Rather, as he was disclosed, he was a witness who was retained to provide his opinion at the preliminary hearing. Similarly, Dr. Lewinsky has not been disclosed as an expert who will testify at trial in this case. Accordingly, his personal financial information related to his company, information related to his work on this case, and information underlying the studies that he's completed is no longer relevant in this case. Now, Your Honor, the U.S. Supreme Court and courts within this state have long held that irrelevant information cannot be subpoenaed in a criminal prosecution. And for that reason alone, because the information that was subpoenaed from Dr. Lewinsky is no longer relevant in this case, the state's motion to compel should be denied and their subpoena should be quashed. Now, in addition to the fact that none of these documents the state asked for are relevant in this case, the state is also barred by statute from obtaining those documents at this stage of the case. Rule 5-511 states that the court by which a subpoena was issued shall quash or modify the subpoena if it requires the disclosure of an unretained expert's opinion or information not describing specific events or occurrences in dispute resulting from the expert's study made not at the request of any party. Currently, Dr. Lewinsky is not retained. Accordingly, because he's an unretained witness in this case, or a witness who served at some point in this case, namely the preliminary hearing, Rule 5-511 prevents the state from obtaining the information sought by its subpoena. Now, furthermore, the state subpoena should also be quashed because it places an undue burden on Dr. Lewinsky. Because he's not retained and has not been disclosed as an expert witness in this case, any burden that's placed on Dr. Lewinsky is undue because he has no role in this case as of now. For those reasons, Your Honor, I'd ask that the court quash the state's August 6, 2015 subpoena and deny the state's motion to compel. And I stand ready for any questions the court has.
If Dr. Lewinsky, his information is not relevant, then why was he retained and why was he allowed to testify at the preliminary hearing?
Your Honor, his testimony and the information he has certainly was relevant at the preliminary hearing. But as Mr. Bregman mentioned, the financial resources are very limited in this case. So at this point, the defense is going to have to make some tough decisions as to who they're going to retain in this case to provide an expert opinion. Those decisions have not been finalized, and accordingly, Dr. Lewinsky has not been retained, and he's certainly not been disclosed as an expert witness in this case, and therefore all of the information that the state has requested is simply irrelevant and would not be admissible at trial. Thank you.
Want to reply?
Yes, Your Honor. Again, I think really it's just two reasons. I'm sorry, just one reason that the defense is objecting to this, because 1 and 2 are essentially the same. They're suggesting that Dr. Lewinsky is not a witness in this case anymore, therefore what we have sought is irrelevant. But words are important, Your Honor. Bill Lewinsky is a witness in this case. Whether he's a witness at the trial in this case may need to be determined in the future, but he has certainly been a witness in this case. The CR number is the same. The parties are the same. The interests are the same. The facts are the same. The evidence is the same. He is a witness in this case. Now, if we end up having problems with Bill Lewinsky's testimony and the court ends up limiting it or excluding him altogether, there's a substantial possibility that the defendants may consider their case prejudiced and may request that the court vacate the trial setting so they can look for another expert. Knowing that that's a possibility in this case, knowing the delay that we already have in this case, it's very important that we get all of the steps leading up to the experts in this case sorted out as soon as possible. All the state is asking for is the court to help us sort out whether Bill Lewinsky is going to continue to be a witness in this case. And if he is, he should respond to the subpoena, because the only reason they gave is that they're not sure whether he's going to continue to be a witness in this case. Bill Lewinsky's testimony and his words are important in this case, not just because of who he is and him himself. Many of the other experts retained by the defense intended to or attempted to rely on his studies and his expertise to bring their own expert testimony in this case. If it wasn't a subject of a motion in limine, it was certainly a subject of on-the-spot objections, which were ultimately sustained by the court in the preliminary hearing when a witness named Ron McCarthy tried to use many of the opinions of Bill Lewinsky in his previous studies to support his own opinion. He attempted to discuss the preposterous notion that once a police officer starts the process of pulling a trigger, it's impossible for them to stop. The court shut that down immediately. But Bill Lewinsky is in this case. And if he's going to continue to be in this case, the jury has a right to understand who he is, where his testimony comes from, and what the bias associated with it is. Because, as I pointed out at the very beginning of all this, industry-funded junk science is dangerous. It can permeate our minds in ways we might not expect and seem innocuous, but can really obscure the truth. And that's why the state needs this information, Your Honor. Thank you.
I'd like to discuss the scheduling order a bit. Paragraph 2 of the scheduling order states that all parties shall produce the results of any scientific evidence by March 18th of 2016. And we have a witness interview deadline by May 6th of 2016. So I'd like to order a deadline for disclosure of any expert witnesses. And I'd like some feedback from the parties with regard to timing of that. I think one of the challenges is that if one side does disclose an expert, the other side would need time to evaluate that expert and then disclose their own expert if they choose to present one. So let me start with the defense on what, if any, requests they have for a deadline on disclosing expert witnesses, in line with the deadlines that are already contained in the scheduling order. And, you know, if you want a few minutes to talk about this, this is the area I want to address next.
Yes, so there's one, is the deadline for expert witness disclosure. Anything else you'd like us so we can get it all?
Yeah, I mean, what's related to that is then a time frame for any responsive type of expert based on that disclosure. This isn't addressed in the local rule, and I think it's something that's important to hammer out in a case like this.
We have just a minute then?
Sure. I'll give you 10 minutes. You can have a few minutes to talk if you need a restroom break. And that'll be a good time for that.